All rise.
Good morning. Please be seated. Ladies and gentlemen, my name is Elliot Sattler. I am a former prosecutor here in Reno for about 20 years, and I was a district court judge at the state level. And I'm currently a mediator and arbitrator, which means that I do private trials and then I try and help people get out of the legal system that they find themselves in. And most importantly, I am a proud graduate of the original high school in Sparks. Sparks High School. So, but I don't hold that against you guys. Nice to meet you. My colleagues will introduce themselves to you as well. Judge Stewart.
Good morning. My name is Miranda Dew. I am a United States District Court Judge for the District of Nevada. You may know in your research that Nevada has one district, federal district court in Nevada. We have two courthouses, north and south. I sit in our unofficial northern division in Reno. I was born in Vietnam, raised in the Bay Area, moved to Nevada after law school, and I've been here ever since. I was in private practice for about 18 years, and then I was appointed to my position about 13 years ago. It's a pleasure to meet all of you.
Mr. Stewart.
Good morning. My name is Michael Stewart. I am the Research Director at the Gwynn Center for Policy Priorities. That's a statewide nonpartisan policy research institute. And before that, I spent over 25 years working for the Nevada Legislative Council Bureau, a nonpartisan staff agency that serves all the legislators. And over that time, I worked and staffed committees in areas such as government affairs, elections, legislative operations, 3 rounds of redistricting, and a lot of natural resource issues. And then before that, I was a couple years at the Secretary of State's office doing election law. So happy to see you this morning.
Could you introduce yourselves to us, please?
My name is Jaden Purdom.
My name is Taylor Say.
My name is Peyton Limich.
Hello, judges. Hope your day is going as well as ours. I'm Drummond Jones. We're Unit 4, top of the great Mr. Tal and Miss Carson, and Brian all the way back there.
Excellent. Well, we'll see how it's going. Let's get started, shall we? Chief Justice John Marshall said in Marbury versus Madison, quote, "It is emphatically the province and duty of the judicial department to say what the law is," close quote. Do you agree or disagree? Who decides what the Constitution means? When, if ever, should different branches or levels of government be allowed to interpret the Constitution differently, and how should such conflicts be resolved? Has judicial review been good or bad for the American Republic? Please explain your position.
We agree the judicial branch is responsible for interpreting the laws and deciding if government actions are constitutional. Alexander Hamilton clarified this implied Article 3 power in Federalist 78. We all decide what the Constitution means, but the court's independence through no elections and life terms puts them in the best position to interpret law free form under influence from the other branches and public opinion. This authority began with Marbury v. Madison in 1803. Chief Justice John Marshall asserted that it is the duty of the judicial department to say what the law is. Judicial review helps protect rights and prevents other branches and states from abusing power.
In Yigwu v. Hopkins, the Supreme Court struck down a San Francisco law that discriminated against Chinese immigrants operating laundries. The court ruled 9-0 that the law violated the Equal Protection Clause of the 14th Amendment.
In Cooper v. Aaron, the court reaffirmed this authority. As school board's officials in Arkansas filed a suit against the Supreme Court's decision of Brown v. Board, the justices had anonymously declared that the Constitution was the supreme law of the land, and that the court's interpretations are binding us to state and public officials.
Different branches of the government should be and have interpreted the Constitution differently. When President Obama bombed Libya in 2011, he believed his Article 2 Commander-in-Chief power justified the strikes. He did not need Congress's approval under the War Powers Resolution. But many members of Congress disagreed because Article 1, Section 8, Clause 11 gives Congress the power to declare war, and the War Powers Resolution required congressional approval for hostilities initiated by the President.
State governments should be allowed to interpret the Constitution differently to meet the standards of their citizens. The 10th Amendment gives all powers not delegated to the national government to the states. such as gun control. The federal government can regulate firearms under the Commerce Clause, but states such as Texas and Montana have passed firearm freedom acts claiming that guns sold and made within the state should not be subjected to federal regulation. These conflicts should be resolved through an ongoing process of elections and judicial review.
Although it has its faults, judicial review has been mostly positive for the Republic by upholding the Constitution, keeping states and the other branches in check, and protecting equality and due process. Matt v. Ohio held police accountable to the Fourth Amendment procedures by ensuring evidence obtained illegally could not be used in court. And in 1966, Miranda v. Arizona held police to strict procedures requiring people to hear their rights during an arrest.
Substantive due process asks not if the procedures were fair while enforcing the law, but rather if the law itself is fair. In Brinson v. Freeman, the Supreme Court upheld a law limiting speech within 100 feet of voting polls to protect voting rights. In Moore v. City of East Cleveland, the Supreme Court supported the substantive right to keep family together by striking down a law that limited the number of people who could live together in one household.
Judicial review is a crucial part of our constitutional framework, but the controversy is often whether unelected judges should set national standards or show restraint and let each state progress at their own through representative legislation.
Thank you.
Pitch two.
So given that conclusion, how do you think judicial review affect our trust in our system of government?
Judicial review has been an overwhelmingly positive thing for the United States of America. We see that in the first establishment we see that judicial review has been a positive part of the United States of America through women's voting rights. When the Constitution was first ratified in 1786, we see that it granted and reserved the power of time, place, and manner to the elections to the states in Article 1, Section 4.
We've seen also in times where judicial review has been bad, for example, in Kumamoto v. United States, where they ruled that it was okay to put Japanese Americans in internment camps. It was not fair to put Japanese in these internment camps, where they came to our country legally to...
We see that this was a bad court case because later on we see that these Japanese Americans were given repercussions. And we also see when the judicial branch has overstepped their boundaries, almost becoming activists, especially in Obergefell v. Hodges and Loving v. Virginia, whenever they made it to where states had to change their laws on interracial and same-sex marriage, granting that marriage is a right given to all citizens.
To backtrack to another good judicial case is U.S. v. Nixon, where it's showing that the president isn't above the law and he has to give over those Watergate tapes.
And this was seen in the Supremacy Clause in Article 6.
Have you seen further examples where the court, in a way, as an institution, engaged in a self-correction in reversing prior presidents?
We've seen the case of Brown v. Board of Education, which overturned the decision of Plessy v. Ferguson, where they determined that segregation in schools is a violation of a student's right to learn. They put in a study that segregation in schools is detrimental to a student's learning.
We also see in Dobbs v. Jackson, which broke over 50 years of precedence for Roe v. Wade, giving the powers to make laws of abortions back to the states.
We also see where Minor v. Happersett declared that the states have the right to determine time, place, and manner, making that the states can determine if women should have the right to vote or not. But this was overturned by the 19th Amendment, showing how we can amend the Constitution to change judicial activism.
So all of that, do you think that undermine the public's confidence in the court, or does that augment the public's confidence in the court?
With the decision of Brown v. Board of Education, I believe that gained strength with the public's opinion in the court's decisions. We see that they overturned Plessy v. Ferguson because it violated 14th Amendment rights and of equal protection. We see that with the decision of Brown v. Board of Education, it was more of a stand of civil rights.
We do see how people may not feel as connected with the judiciary, especially because 5 out of our 9 justices right now were nominated by presidents that didn't win the popular vote, then approved by senators who don't even represent 40% of our population.
Going back to my example of criminal to the United States, we can see how it could make U.S. citizens lose trust in our judiciary, especially immigrants coming here on the pursuit of happiness only to get thrown into internment camps just because of their race.
To build off my colleague Peyton, a way we can put a check on this is by amending the Constitution. We can start by Article 2, Section 2, Clause 2, with every president having 2 nominations for 2 new justices, and with Article 3, Section 1, having the senior justices who would serve times of life term, change that to where the 2 nominated justices would replace the 2 senior justices, and the way we can do this is with Article 5, the amendment process.
Mr. Stewart?
Mr. Pruitt, you had mentioned something. You said that states should be allowed to interpret the Constitution, but the conflicts that may arise during that process could be solved through judicial review, but also elections. How can you crosswalk for me some of the challenges that we've seen now with elections in the last maybe 10, 12 years, and the courts really sort of stepping in and maybe playing their hand a little bit in our elections process as part of this judicial review when the elections themselves, theoretically, could address some of these state conflicts?
You see with Rucho v. Common Cause, where partisan gerrymandering was going on, and voters felt like that their vote wouldn't get across if they were to vote.
We see in this interaction of state and federal powers through an example of federalism. In the case of United States versus Texas in 2025, the judiciary had determined that Texas could politically gerrymander their state, favoring the Republican Party. However, this could be a bad case where in Texas, I was born in Galveston, Texas. So if I were to go back, I would question if my vote truly matters, if my family who stays there is truly matters.
In what way? I don't know. Are you lost me there?
Well, Texas is politically gerrymandered to favor the Republican Party. So if I were to move back to Texas, I would question if my truly matters if Texas is politically gerrymandered anyways.
Okay, now I understand. I want to kind of circle back to the original question. The term emphatically, Chief Justice Marshall uses the term, it's emphatically the province, as if it goes without any question that it is the province of the Supreme Court to decide what the Constitution means. Can you direct me to where specifically in Article 3 or any other portion of the Constitution it specifically says that, if it is so obvious?
Well, in Cooper v. Aaron, the judiciary reaffirmed their power, saying that they are equal to the Constitution with the Supremacy Clause, and that how the Constitution is the supreme law of the land, and if they are equal to the Constitution, then their say is the last say.
But my question is more, is there anything in the Constitution itself? You've done an excellent job during your presentation describing different articles in the Constitution and how they apply to the question. But where in the Constitution does it say that the Supreme Court has the power of judicial review?
It is not in the Constitution that specifically outlines judicial review, because the judicial court gave themselves this power in Marbury v. Madison in 1803.
Okay. Can you tell me about if in any way the analysis would be impacted by, say, Federalist 78?
James Madison stated in Federalist 78 that it should be up to the judiciary to determine if any government laws or actions are constitutional.
Judge Hugh, do you have a follow-up?
I think she was in the opening that, also citing to the Federalist 78, indicating that the court is more appropriate to interpret the Constitution because they're like the justice's lifetime appointment. But then I heard a conflict. I think you indicated that there should be limits to that lifetime appointment. How do you reconcile the conflict, if at all?
We see that the judiciary, because of their life tenures, are supposed to be nonpartisan. But with these life tenures of changing it to 18 years, we can see that because their decisions are timed between these 18 years, they have a duty to be nonpartisan. And with these 18 years, it allows for there to be a fresher court, and then allows Noah Feldman's quote of having each generation deserving their own constitution really truly be enacted.
And we can do this through Article 5.
So do you believe in our fractured society now that you could get an amendment to the Constitution at any time?
For an amendment process, 3/4 of the states have to agree. I believe that is an extremely hard process to actually get an amendment passed. And with so many different opinions in the states, it will truly be a task to get an amendment process.
Mr. Stewart?
So let me just this is kind of a broad question, but so what if judicial review did not exist at all? How would constitutional disputes really be settled? Like, is there another system that might work better?
Historically, we have seen with the Star Court led by King George, most of these courts were biased. The King George would be able to change their pay, kick them out of the court, or have the location of the court happen anywhere at any time. Usually put in Great Britain. So most people would have to travel far and wide, take time off their job, lose pay just to go to these courts that were just biased. So why would it matter?
But if we didn't have the judicial branch, we would ultimately have to look back at the people and what we can do to amend the Constitution or make change. And we see this specifically with
Gideon B. Wainwright, where Gideon advocated with using his enlightened self-interest for himself and for the people to advocate that his Sixth Amendment right to counsel and an attorney was violated.
I was waiting for that. I was
Yeah.
about to ask you a question. Good timing.
Yeah.
Well done. I really enjoyed your opening remarks because you made a declarative statement at the beginning. We agree. And then you went through and you backed it up. And I'm always waiting to hear kind of like the different points in the question. So you really did an excellent job addressing each and every one of them. I also enjoyed the fact that you appeared to have a very thorough and broad knowledge, not of just the cases, and you would cite them and give a brief description of the case, but also constitutional principles, and you're bringing in historical individuals, and you also gave us some good citations to the amendments and to the articles of the Constitution. So I thought that that all was very, very well done. I will tell you that it has happened to me standing in front of a judge or a room full of people that I have forgotten something. You forget a name or you forget a specific case. And the way I describe it is, it seems like it takes forever and you can hear the blood rushing through your ears. It's just like a throbbing noise in your head, and that's all you can do. It happens to everybody. So, I mean, I was a trial attorney forever. It happened to me. You did a great job picking each other up. But I would suggest when it happens to you, just take a really deep breath. It's okay. So just let it, and maybe unless your colleague really needs help, let your colleague pick it up, because that's when that person really shines. But you did a really good job helping each other out there. I thought your presentation regarding the appointment process, so it went by pretty quick, but a new president gets to appoint 2 new Supreme Court justices, and what I took from it was like the old guys get kicked to the curb. It was interesting. I don't know how it would ever work, but at least it was an interesting proposal. I'm making light of it, but it's just, it was something I would like to sit and discuss for an hour and kind of develop the pros and cons of it. Be very careful though. I wrote it down quickly. I think you threw out some statistics that I'm not quite sure are accurate about the current composition of the Supreme Court. I forget the numbers, but I think you said at least 5 of them were appointed by individuals who did not win a majority of the popular vote. I don't even know if that is technically accurate. I would go back and make sure about that. But I don't know. I'm not saying you're wrong. It was just one of those things that when I heard it, I went, wait a minute, I need to think about that a little bit more. And then confirmed by senators who don't represent this certain number of people. Be very, very sure about those statistics. If you're right, I apologize. But it was just one of those things I went, not sure. Overall, great presentation. And by the way, where is it in the Constitution that it says that is a complete trick question. It's nowhere. It doesn't exist. So that's the hard part of it. Tell me where it says that. It doesn't. So, but yet, once you got over that little hurdle, it was like, then you started really digging into the question, did a good job with it. So excellent job, and good presentation.
No,
Oh, by the way, I'm sorry. Madison did not write Federalist 78. Hamilton did. Don't worry about it. Just so that was the smallest little teeny tiny thing. Madison didn't write it, Hamilton did. I apologize.
That's right. I thought you did a really good job answering that question about where in the Constitution it indicated that the Supreme Court has judicial review, because it's, you pause and then you took confidence in yourself when you answer that question. I enjoy seeing the dynamics. All four of you are more relaxed. I think as the presentation proceeded, and you help each other out where you need it, and you turn to each other to let each other chime in. So I think in terms of the presentation and the style, I really enjoy seeing that. I also am so impressed by the breadth of the topics that you cover. You threw out gerrymandering, voting rights, executive orders. Well, that's kind of part of our current environment now, declaring, sending Japanese Americans to internment camp and the consequences of that. What else? Education. So these are all really broad range of topics that are complicated, but also reflect that you've done a lot of reading and research, and that I'm impressed by that as well. So thank you. I really enjoyed the presentation.
Thank you.
I just echo my colleagues. It was excellent. I wrote down, the first thing I wrote down when I walked in was super polished. I have to say, it was just like, you literally all opened your binders at the exact same time. I noticed it immediately. And so that was excellent, you all. And just the same look, and your flow in your opening was great. And then throughout a line of pretty difficult questions, I think and a few little, maybe trying to trip you guys up, and you handled it really well. And even passing the baton and, coming in for lifelines here and there, that was really, really nice. I'd also echo Judge Du's point about the broadness and the depth of what you covered. It was really impressive. So, and I guess just a little bit more rehearsal as you kind of prep for your next stages. So there's a little bit more rapid fire and quicker sort of on the spot questions, which, believe me, it's very hard to do. And so you guys navigated that really well. So congratulations.
Thank you.
Thank you.
Well done.
All right.
Thank you.
Great job.
Good job.
Really well done.
Great job. Thank you. Thank you.
Thanks for helping out.
Great job.
Thank you. Appreciate it. Thanks so much.
I know, sitting around waiting.